I'm going to give a brief introduction now to set the general theme of this session, and we'll talk in general terms about data privacy and security, mostly from the legal aspects that were also briefly touched on yesterday. And what I'm going to talk about today isn't actually a product of the ETRICS program so much as something that we've intensively discussed within ETRICS. So here's the acknowledgement that we've been generously supported by the IMI. And also, because I'm going to talk about legal things, here is also a disclaimer. I'm not a lawyer. Data protection and privacy are really complex subjects, and they are controlled by a wide range of laws, legislation in the various EU member states, for example. And this presentation is not intended to be legal advice in any way. It's more just to alert you to some of the potential pitfalls and problems that you may encounter. And for detailed information, you really have to go to your own lawyers or your supervisors in your institution to make sure that you're compliant with everything that you should be compliant with. So, why do we need to be concerned about the privacy and security of data? Science, the progress of science, as we all know, depends on data. And I'd like to just go back to 1665. 1665 was a landmark year in science. This was the year in which the first scientific journals were published. The very first was the Journal des Savants, which was published in Paris, a matter of weeks before the first issue of the Philosophical Transactions of the Royal Society was published in London. So the French just managed to scoop the British on that one. Yes. However, the Journal des Savants is no longer published, and the Philosophical Transactions, after more than 350 years, are still going strong. So being first isn't always the best solution. If we then fast forward to April 2003, that was when the successful completion of the Human Genome Project and the first draft genome was published. Why do I mention that? Because up to that date, mankind, had collected a lot of information, around about 5 exabytes, 5 million terabytes of information. At least this is what the chairman of Google tells us. But how accurate the figure is perhaps not so terribly critical, as it's probably not so critical to know exactly how long it takes us today to accumulate this amount of information, but it's in this around about the time scale of 2 days. So between 1665 and 2003, we accumulated quite a lot of information, and now we're generating the same amount of data approximately every 2 days, which amounts to 20, depending on your estimate, between 20 and 50 terabytes a second, which is a lot of bytes. I mention this because quite a lot of this information that's being accumulated can be classified as personal information, personal data. So it's the information about the location of your cell phone, your internet surfing, your banking, the data from your health apps, and all of this kind of thing. And because a lot of this is classified as personal data or private information, then the various privacy laws of states worldwide comes into play. The numbers here are not really the critical part of what science is about, because this is just data. And data, as Reinhardt reminded us in a very quotable quote yesterday, data is like soup. It's kind of messy, and nobody really knows what's in there. The important thing about what we do as scientists is to extract knowledge from the data. The amount of knowledge, of course, can be contained in a much smaller amount of electronic information than these multiple terabytes that are accumulated at such an incredible rate. And it's the knowledge that's much more important. So what Einstein published, or what Shakespeare wrote, or since we're in Barcelona, what Antoni Gaudi succeeded in doing here in building the Sagrada Familia and something like that, that's the knowledge that's important for mankind. But in order to get that knowledge, we have to first of all create the data, and then we have to extract the knowledge from that data, and that process of extraction, the processing of the data, is what is then actually controlled in our society now fairly strictly by the various laws that are in place. If you look at the situation worldwide, the map is actually fairly heterogeneous. This is a world map. The protection of personal data worldwide is generally a constitutional right. I'm not sure if there's any state on Earth that does not guarantee the privacy of the individual in their constitution. But data protection is something that has not been enacted in all countries by any means. And on this map, the dark red countries, for example, mostly Western Europe and North America, are those countries where there are very strongly constructed and also very strongly enforced data protection laws in place. Where the color gets a little weaker in the orange, these are countries where there is robust protection, but not, for example, as strong as we have in the EU. And the yellow colors are a little weaker, the green colors have limited data protection, and in the gray states, as it were, there is no specific data protection legislation. So the data protection is only ensconced in the Constitution. Since we're having a meeting in Europe, and since we're mostly European projects, I will concentrate today only on the aspects of European data protection law. And as I think probably most of you are aware, until very recently, data protection in the European Union depended on the Data Protection Directive that was enacted in 1995, which was the basis then of the creation of individual data protection laws in the member states of the European Union. However, last year in May, the General Data Protection Regulation was finalized in Brussels, which is a revision of the directive. It has been extended quite significantly and aims at providing a set of fully harmonized rules for processing and use of personal data within the member states of the European Union. It came into force last May on the 24th and will replace the directive on the 25th of May. So as of today, we have 375 days until D-Day, as it were. Until then, we're dealing with a patchwork of national legislation, but everybody at the moment is working quite hard to align themselves with the terms of the regulation, so that when it becomes the driving legal force, we'll all be prepared for it. So what are personal data, and what is then the core of what this regulation is all about? Personal data means any information relating to an identified or identifiable natural person. So we're talking about human beings, and identifiable means the person who can be identified directly or indirectly. And this is the core of the discussion, for example, surrounding the critical issues of whether you pseudonymize and anonymize data and questions like this. And in particular, people can be identified, of course, by their name, by their social security number, their location data with their handy, an online identifier like your IP address. There's an extremely long list of information that can be used as a means to identify you or any other individual person as who they are. And the legislation applies to the processing of exactly this kind of data. Processing means collecting it, recording it, storing it, consulting it, analyzing it, transferring it to a different server, whatever. Any of this is processing and is controlled by these laws. For the purposes of our scientific research, however, there are types of data which are characterized as being sensitive under Article 9 of the GDPR, which relate, for example, to racial or ethnic origin, people's beliefs and so forth, but more importantly for us, data concerning health, in the GDPR, as opposed to the directive, this data now specifically includes genetic data and also biometric data, if this can be processed to uniquely identify a person. And this is one of the aspects of the regulation where the category of sensitive data, which is very relevant to our research activities, has been extended. One of the most interesting aspects of the regulation, and I mentioned this in the discussion yesterday afternoon, is that the processing of this sensitive data is prohibited except under certain conditions. These are things that we actually know, we deal with these in our daily life. There are a long list of conditions, a couple of pages of them, but there are two that are most likely to apply to the processing of personal data in biomedical research. The first exception is if there is explicit consent of the data subject that their data can be processed, or if the processing is necessary for in the public interest or for scientific and historical research purposes. So these are the exceptions that allow us to operate on personal data. The law does not apply to the processing of anonymous or anonymized data. So anonymous data is data that's collected anonymously. Anonymized is data that has been modified so as to not contain elements allowing the identification of a person. It has been mentioned by several speakers already in this room that anonymization cannot be an absolute process. If you completely anonymize the data, then it's completely useless for science. And this is also recognized in the regulation. And this is very wordy, but I reproduce it here. You can read it later at your leisure, because the people who drew up the text of the regulation are very specific about what anonymization means, and basically it means that if you're going to anonymize, you have to take into account not only whether the elements of the data are relevant for being able to identify a person, but under what circumstances. And so, for example, whether means are reasonably likely to be used to identify a person, account should be taken of objective factors such as the cost, the amount of time, and consideration of the available technology at the time of processing. And so if it's going to cost a hell of a lot of money, or the algorithms are exceptionally complex, then maybe the anonymization is adequate. But if you have a really powerful algorithm and you're dealing with a very small data set, then you don't need to put a lot of effort into it, and then maybe the anonymization process that you've chosen is not adequate. So this is also taken into account in the legislation. And just as a sort of footnote, the legislation does not apply to the personal data of deceased persons. And here there's quite a lot of variation among the EU member states as to which laws apply to the protection of deceased persons. And it doesn't apply to legal persons. And again, the laws applicable to legal entities also vary among the member states, and don't, as a rule, concern us greatly when we're processing scientific data. So what does this mean for the individual? This is very important, as was already mentioned yesterday. It's one thing to have data and process it, but the data actually belongs to the data subject. We have some exceptions, as was mentioned by Nicholas Blomberg yesterday. In Denmark, the law says actually the data belongs to everybody unless you opt out. But in most states, the data belongs to the data subject, and the scientist or anybody else holding that data is a data steward and has the responsibility, for example, that if data is going to be processed, that the data subject has the right to be informed, the data subject has the right of access to their own data. They have, under the regulation now, they have the right to have this data corrected if they feel that the data that's being stored is in any way incomplete or inaccurate. So it's enormous ramifications, for example, for Facebook or other organizations like this. They also have the right to have the data erased from a database. That's something that's normally incorporated into a standard informed consent, that you can have your data erased. They have the right to restrict the processing. If they think that you're going too far with their data, then they can have that restricted. There is the right to data portability. This means that the data subject has the right to say, I'm going to transfer my data to another data controller. I need a copy of the data and I'm going to give it to somebody else. That is their right. They have the right to object to the processing, and they have rights in relation to automated processing, which automated processing is not necessarily so relevant for what we do in scientific research. These are things that have to be borne in mind, mostly at the outset of a project, so that you make sure you're collecting the data in such a way that you're not going to be infringing on people's rights. And so what does this mean then for an institution, for your research institute, for your employer? Basically, we need to keep patients informed. We're not allowed to keep patients in the dark. It means you need a clear informed consent, of course, and parental consent if the data subject is under 16. It means that if the individual asks for it, you have to be able to provide them a copy of their data on request, and erase the data if also requested. It means that you need to proactively demonstrate that you are compliant with these requirements. And in constructing your data management systems and processing systems, and this is new under the regulation, we have what's called privacy by design. This means that the algorithms and the infrastructure that you use in your research has to be constructed in such a way that the privacy of that data is guaranteed by the way the system is built. And that is now a requirement. And two other new aspects that have to be borne in mind. There is a mandatory requirement to conduct a privacy impact assessment. And the regulation states that if the processing of personal data may potentially harm an individual. In other words, it may identify them or cause any other kind of harm. Then the processor is required to conduct a privacy impact assessment before processing that data. There are no absolute metrics for making a decision like that. This is a risk assessment, and so it's up to the individual project or the individual scientist to decide whether an impact assessment is required. And the other thing is that if there is a security breach and data is released, then there is a requirement within 72 hours to notify the data subject. Again, here there are some stipulations. If the nature of the data that's been released is such that there is negligible risk of harm to the data subject, then it's not required. But this again is then a risk assessment that has to be made in the case of a data breach, whether a notification is required or not. So what does this mean for your organization? A little bit about security. Obviously, the facilities and systems have to provide an adequate level of protection and security. This is something that we all know about, and we assume that we do things correctly and that everything is safe, and the confidentiality and so on of the personal data have to be guaranteed. This is easier said than done. I mean, we have the example just last weekend of WannaCry encrypting people's data, causing absolute chaos. And so one of the things that the systems administrators have to ensure is that data is really adequately protected against hacker attacks and viruses and so forth, so that none of us wake up in the morning, turn on the computer, and find a notice asking us for $300 in bitcoins to de-encrypt the data that somebody has encrypted overnight. Or we come in the morning and find that our entire data has been downloaded by somebody who wasn't supposed to have access to it. So, just summing up briefly, the goal of the GDPR is to produce a single data protection law for the EU, allowing free flow within the EU, and regulating or forbidding the flow to countries where the data protection is considered to be inadequate. The GDPR, interestingly, because it's a regulation, does not require any enabling legislation to be passed by any of the member states of the EU. This means that on the 26th of May next year, this regulation automatically comes into force in all the member states. However, of the 99 articles in this wonderful piece of legislation, 50 of the articles have some provision, at least, in some cases quite wide provision, for variance. So the member states are permitted, in certain aspects, to bring in their own stipulations to make a variance against the regulation. So we can expect that also, although we now have a unifying regulation, in future we are still going to have to deal with the fact that there may be variation among the member states in the details of how we are allowed to use or transfer data. We don't know, of course, at the moment to what extent we're going to be affected by this, because none of the member states so far has released their new legislation based on the regulation as opposed to the directive. But we have to be prepared for this. And what we'll now do is, okay, first of all, that's all I'm going to say about these legal details. So thank you for your attention for that. And in the talks that we will hear in the rest of the afternoon, the various aspects of the practicality of working with data will be discussed in a little more depth.
For pharma companies, what does it mean, or for clinical trials, what does it mean to have data protection by design?
And sorry, for?
Clinical trials for data from pharma companies, what does it mean to have data protection by design, this embedded process during the design of the studies? How do you implement this?
I understand it as meaning that somebody who is collecting data and processing has to have the technical capability of ensuring that all of that you have adequate security, that you're secure from hacker attacks, that you have internal security, that only those people in your organization who are allowed to have access really can have access, and all of these kind of things.
We can see on the implementation of the security measures that several of the steps they rely on the security of the operating system that people dealing with personal data is using. And this comes now to a business problem for the operating systems providers, that they have failures in these systems that are subject for attacks from hackers. In this case, what would be the shared responsibility for a data leak when it comes from operating systems provider, for example? I would say that they co-share a great amount of responsibility on a putative data leak, for example.
Yeah. And I'm sorry, I'm not a lawyer, and so I can't answer the question. But do you know?
Yeah. Under the directive, it's only the data controller who is responsible. Under the regulation, they co-share the responsibility, the data processor and the data controller.
Yes, but I think your question was, if the problem is, for example, a loophole in Windows that allows a hacker to gain access.
I suppose that it should be the Microsoft who is responsible.
Yeah, but it's first the pharma company that gets sued, and Apple say sue Microsoft.
In fact, the data controller is supposed to check that the data processor is in compliance. But if there is a breach, there are still some responsibility.